Very good evening, dear friends. I welcome each one of you to our AOR Aspirants Academy. This is our 72nd lecture. But before going to the topic, it is our regular practice that we recite preamble of the Constitution of India, because as a true Indian, as a true citizen of this country, you should achieve the noble idea laid down by our founding fathers and founding parents, that is enshrined in the preamble of the Constitution of India. So I respectfully request each one of you to recite preamble along with me, with a faith in the system that preamble our goal and preamble our soul. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. This is our 72nd lecture. In this lecture, we are going to see in detail. So what we have seen in the earlier lecture, let us keep that as a guiding light. An overview of the entire judgment. Now let us see in detail in this case. First is, this as matter has come before a 5 judges bench. Why it is a leading case? Let us answer this question first. Firstly, it was decided by Honorable 5 judges. And Honorable Chief Justice Dr. D.Y. Chandrachud my Lord has authored this judgment on his behalf and on behalf of 3 other learned judges. And it is unanimous judgment. All 5 judges have agreed it is a unanimous judgment. But Honorable Justice Sanjeev Khanna, my Lord, has concurred with Chief Justice of India, Dr. D.Y. Chandrachud, but he has given his separate opinion. Let us understand this basic first. So this is about the judges who has decided this judgment. Now the second question is, how this matter has come up before a constitution bench. It is master of the roster, where the Honorable Chief Justice of India has power to constitute any matter when it involves a substantial question of law as to the interpretation of the constitution. They can constitute not less than 5 judges. So that is under Article 145 Clause 3 of the Constitution of India, which empowers the Supreme Court to constitute constitution bench. Is it clear, dear friends? So matter has come before the 5 judges bench. Why it is a leading case? Why it is a leading case? Because it involves substantial question of law as to the interpretation of the Constitution 21, 19(1)(a), whether there is an arbitrariness under Article 14. So therefore, interpretation of the Constitution is involved. Therefore, it has become a leading case and concerning the national interest. So therefore, it is a leading case in my humble opinion. Now let us see, dear friends, what are the important aspects delivered by our honorable judges. Dr. D.Y. Chandrachud, Chief Justice for himself, and Justice Gavai, Justice Pardiwala and Manoj Mishra, and Justice Khanna concurring but given separate opinion. The headings are background. The background is, let us see what is their challenge. First, let us understand the challenge. So, I am going to take you to the background of the case. The petitioners have instituted proceedings under Article 32 of the Constitution, challenging the constitutional validity of the electoral bond scheme, which introduced anonymous, not disclosing who is who, what is what. Everything is clothed in secrecy. So, anonymous financial contribution to political parties. The petitioners have also challenged the provisions of the Finance Act, which, among other things, amended the provisions of the Reserve Bank of India Act, the Representation of the People Act, Income Tax Act, that means we said not to maintain the account, Income Tax Act, and the Companies Act. Even the loss making companies can fund. Even there is no ceiling at all, unlimited contribution can be made by a corporate entity. So whether would it amount to manifest arbitrariness? So these are all the challenges made by the petitioners. Now let us understand, dear friends, what are the issues involved. If you want to know the more specific provisions which are under attack, which was under challenges, the petitioner instituted proceedings under Article 32, seeking a declaration that the electoral bond scheme and the following provisions be declared unconstitutional. Section 135 of the Finance Act 2017 and corresponding amendment in Section 31 of the RBI Act. This is the specific provision under attack. B. Section 137 of the Finance Act and the corresponding amendment in Section 29C of Representation of People Act. C. Section 11 of the Finance Act 2017 and the corresponding amendment in Section 13 capital A of Income Tax Act. Last is Section 154 of the Finance Act 2017 and the corresponding amendment to Section 182 of the Companies Act. So these are all the challenges before the Honorable Supreme Court under Article 32. Now let us see what are the issues involved. Very important. Issue is very simple. Let me read, dear friends. First issue is, there are only two issues. Whether unlimited corporate funding, to political parties as envisaged by the amendment to Section 182 subsection 1 of the Companies Act infringes. This is very important. How are you going to attack? Whether it infringes the principle of free and fair elections and violate Article 14 of the Constitution. So the unlimited funding by the corporate entity, they are saying it violates, it infringes free and fair election. I would like to say here, dear friends, free and fair election is also part of the basic structure of the Constitution. So it violates the basic structure. That is one of their grievance. Second aspect is, how come there can be unlimited funding? Therefore, it is arbitrary. Therefore, it violates Article 14 of the Constitution of India. That is their first issue. Second is whether the non-disclosure of information on voluntary contributions to political parties under the electoral bond scheme and the amendments to Section 29C of the RPA Act, that is Representation of People Act, Section 182 subsection 3 of the Companies Act and Section 13A(b) of the Income Tax Act are violative of the right to information of citizens under Article 19(1)(a) of the Constitution. So these are the issues were under consideration before the Honorable Supreme Court. Now, how it is being dealt? First is scope of judicial review. Now we are going to analyze. So we have understood the background of the case. We have understood what are the issues involved. Now now we have understood the judgment also. Judgment has held it is unconstitutional. Yes, electoral bond or the other amendments are violative of 19(1)(a). Right to privacy is not available. an electoral bond unlimited funding is a violation of Article 14 because it is manifestly arbitrary. So that is the judgment. But to reach the judgment, it must be supported with reasons. Giving reasons for the judgment is also a part of the principles of natural justice. People should know of this, the people of this country should know on what basis the electoral bond scheme was declared unconstitutional. What are the reasons? This is where the wisdom of the Honorable Supreme Court judges, their rich experience, the effective assistance by the learned advocates comes into the picture. So now let us analyze their reasons. Ratio decidendi. So the Union of India, now the Union of India makes a submission before the Honorable Supreme Court. The Union of India submitted that this court must exercise judicial restraint, which while deciding the challenge to the electoral bond scheme and the statutory amendments because they relate to economic policy. That was their submissions. It is related to economic policy. Therefore, Honorable Supreme Court should not entertain. They should exercise judicial restraint. They should not interfere in electoral bond scheme. But at para 42, dear friends, 43 rather, in fact, it is evident from the correspondence, exchange of letters between the Ministry of Finance and RBI on the apprehensions of the bonds being used as an alternative currency that the bonds were introduced only to curb black money in the electoral process and protect informational privacy of financial contributors to political parties. The Union of India has itself classified the amendments as an electoral reform. Thus, the submission of the Union of India that the amendment deal with economic policy cannot be accepted. So this is on maintainability. They say no, we will interfere. We will check whether there is a constitutional validity or not, because judicial review is also a basic structure, part of the basic structure of the constitution. So they said we have got a right to see, we have the power. Now regarding the presumption as to the constitutional validity that we have already discussed. Now this is very important, this is fundamental. When an enactment, when a legislation is challenged, so the Honorable Supreme Court, what do they consider? They have given the answer. What we will consider to test the constitutional validity of the act. The Honorable Supreme Court judges at para 57, they say, I will first explain and then read it out. We will not see the goal or aim of that legislation. We will not see the aim of that legislation, but rather we will see the effect of the legislation. What is that effect? Effect on what? There is a gap. Effect on part 3, that is fundamental rights. Does it violate any of the fundamental rights of the citizens of this country or not? That we will decide. Or does it damage any other constitutional provisions? That we will see. That is the test. We will not see the goal. Meaning thereby, the Union of India has introduced electoral bond scheme with the goal that we will curb the black money. That is their goal. But we will not see the goal. How do you achieve that goal? What is the impact? You are violating Article 19(1)(a) of the Constitution of India. You are infringing the fundamental rights of the citizens of this country. We cannot tolerate. As a Supreme Court, being the custodian of the Constitution of India, being the protector of the Constitution of India, we will not see that injustice caused to our citizens. Therefore, we will strike down. That is what we will see. We will see the impact on fundamental rights and other constitutional provisions. For example, if somebody throw a stone at our home, if they throw a stone at neighbor's home, we may go and ask, we may not go and ask. We will say, why should we interfere? But if somebody throw stone at our home, we will go out. Who is that person? We will shout. We will try to see why we have done it. Same manner, if any government damages the constitution, who is the owner, custodian? Is the Supreme Court of India. Very recently, Ladyship Honorable Justice B.V. Nagaratna ji, when she was delivering a lecture in one of the colleges, don't think that Supreme Court alone is the custodian of the constitution. Who has given the constitution? We, the people of India, given to ourselves this constitution. So every citizen of this country is the custodian of the constitution. That is what we need to value our constitution, dear friends. Therefore, we are reciting the preamble every day. Now let us see. 57. The challenge to statutory amendments and the electoral bond scheme cannot be adjudicated in isolation without a reference to the actual impact of money on electoral politics. This court has in numerous judgments held that the effect are not the object of law. Effect on what? On fundamental rights and other constitutional provisions must be determined while adjudicating its constitutional validity. The effect of provisions dealing with electoral finance cannot be determined without recognizing the influence of money on politics. Therefore, we must bear in mind the nexus between money and electoral democracy while deciding on the issues which are before us in this batch of petitions. So this is one of their findings, dear friends. So we have seen judicial restraint cannot be stopped. That is not applicable. There is a presumption that the petitioners has established that it is violating 19(1)(a). Fine. Number two, how to test the constitutional validity of any legislation? We will not see the goal of the act. We will see the impact, effect of the act on fundamental rights or on any other constitutional provisions. So this is what. Next, let us go to 19(1)(a). Let us see. Now they are going to test whether petitioner's right under 19(1)(a) is violated or not. So I am going to read para 57, dear friends. That is over. Para 62. Article 19(1)(a) has been held to guarantee the right to information to citizens. The judgments of this court on the right to information can be divided into two phases. In the first phase, this court traced the right to information to the values of good governance. So we are talking about information. What sort of information we are talking about? We are talking about right to information to the values of good governance, transparency and accountability. These judgments recognize that it is the role of citizens to hold the state accountable for its actions also and inactions, and they must possess information about state action for them to accomplish this role effectively. So to question the authority of the government, there should be a transparency. Only then we can check whether their action is good or bad. If it is bona fide, we are happy. If it is mala fide, we can challenge it before the court of law. So if it is good governance, we are happy. If it is a bad governance, we can go to the court. So everything is possible only when there is a transparency. Otherwise, government can be made accountable. So our discussion indicates that, I am reading para 66, dear friends. Our discussion indicates that the first phase of the jurisprudence on the right to information in India focused on the close relationship between the right and open governance. The judgments in this phase were premised on the principle that the citizens have a duty to hold the government of the day accountable for their actions and inactions, and they can effectively fulfill this duty only if the government is open and not clothed in secrecy. That means transparent government. Para 68. a crucial aspect of the expansion of the right to information in the second phase is that right to information is not restricted to information about state affairs, that is public information. It includes information which would be necessary to further participatory democracy. It is not mere casting a vote and waiting for 5 years. Every action of the government must be made transparent. Therefore, a citizen of this country can know what is going on. So, it includes information which would be necessary to information about the functioning of public officials. The right to information has an instrumental exegesis which recognizes the value of right in facilitating the realization of democratic goals. But beyond that, the right to information has an intrinsic constitutional value, one that recognizes that it is not just a means to an end, but an end in itself. And after discussing many judgments, the principles were enunciated, dear friends, in 3 paragraphs. With this, we will conclude for today, and remaining aspects we can cover it in next lecture. So, the following principles, I am reading para 80 because it is running to more than 200 pages. So, make a note of these relevant paragraphs, and this will be sufficient, in my humble opinion, for your AOR examination. The following principles can be deduced from the decision of this court in ADR and PUCL. These are the 2 earlier decided cases. From this, what are the principles? We are focusing on the principles. 80.1. The right to information of voters, which is traced to Article 19(1)(a), is built upon the jurisprudence of both the first and the second phases in the evolution of the doctrine. Dear friends, Article 19(1)(a) or Article 21, it is evolving. First, what did they say? Right to speech and expression alone. Thereafter, right to information about the candidates. Here in this case, not only the candidates, but also the parties. Because only when we know the ideology of the party, we can cast vote. So, not only the parties, but also what is the fund that they receive. So, how it is being expanded. So, this is where the evolution of doctrine, this is where the wisdom of the honorable judges, they evolve. They will interpret and they evolve the constitutional provisions for the benefit of the citizens of this country. So, the common thread of reasoning which runs through both the first and the second phases is that information which furthers democratic participation must be provided to citizens. Voters have a right to information which would enable them to cast their votes rationally, intelligently, because voting is one of the foremost forms of democratic participation. 80.2. First point is 80.1 is over. This is 80.2. In ADR, this court observed that while the disclosure of information may violate the right to privacy of candidates and their families, such information must be disclosed because it furthers public interest. In ADR case, what they have held, the Honorable Supreme Court, that you have to inform about the candidate. The candidate has to disclose what is their asset. So they say it is right to privacy. So it violates my Article 21. No, nothing doing. Because if you are going to disclose your assets, if you are going to disclose the information about the criminal records of the candidate, the voters will understand whom to vote, whom not to vote. So therefore, your privacy will not come into the picture because it furthers, it promotes the public interest. That is important. The opinion of Venkatarama Reddy, justice in PUCL case, also followed the same line of reasoning. Justice M.B. Shaw, writing for himself, and Justice Dharmadhigari held that right to privacy would not be infringed because information about whether a candidate is involved in a criminal case is a matter of public record. Anybody can go to e-court services, put their name and we can find out, because criminal records, court records are public records. So it's a matter of public record. So information about the candidate, about the criminal background is not violation of their right to privacy. Similarly, the assets or income are normally required to be disclosed under the provisions of the income tax, which you are already doing it. So therefore, it will not amount to infringement of right to privacy under Article 21. The third aspect. The voters have a right to the disclosure of information which is essential for choosing the candidate for whom a vote should be cast. The learned judges in PUCL differed to the extent of what they considered essential information for exercising the choice of voting, whether the information of contribution of the fund, whether will it make, once the information is disclosed, whether they can make an informed decision while voting or not. That is the question. 81. While relying on this judgment of this court in ADR and PUCL, the petitioners argue that non-disclosure of information on the funding of political parties is violative of right to information under Article 19(1)(a). This court needs to consider the following two issues to answer the question. Let us see the issues, we will find the answers. What are the answers? We will see it later. The two issues are whether the requirements of disclosure of information about candidates can be extended to political parties. This is where, see, the beautiful evolution takes place here. Whether the requirement of disclosure of information about candidates can be extended, doctrine is being evolved, can be extended to political parties. That is the first one. Second aspect is, if the answer to A above is in affirmative, yes, it can be extended to political parties also. If the answer is yes, the next question follows, that is, whether information on the funding of political parties is essential for exercising choice on voting. Once that information is available to the voter, whether based on that information, can he make a right choice while voting? Whether that information is essential, is it relevant information or irrelevant information? That is to be seen. So these are the issues, and how it is being analyzed and how it is being answered by the Honorable Supreme Court. We will see it in the upcoming lecture. Thank you so much, dear friends, for your patience hearing. Thank you so much.